we have, yeah, cool. So Mark and June, how are you guys?
We are good, thanks.
Okay.
We are here. I'm just
Yeah, we'll just start in a few minutes. We'll just wait for 3 more people to come. It's we have I think we're having a lot of like end of term fatigue, but I hope you guys had fun on Friday.
yes, yeah, it was really good.
Yeah, no, thank you. It was really nice working with you.
Is that
Cool.
visible? Is that visible to you now?
Yeah, it's visible. So just in case, Francisco, sometimes the speaker doesn't get to see when people ask questions. So just keep track. But yeah, super excited. You know, Francisco is working his ass off like you saw on Friday, and you're in fantastic and capable hands. I'm just going to let Francisco lead today, if you don't mind.
Yeah, that's fine.
That's perfect. Cool. Awesome. So thank you everyone for joining. This is a very exciting workshop that we have with Keltie, and I think perhaps we can wait 1 more minute before starting to let everyone join us. I think this is one of the workshops that really can put you ahead in terms of thinking about the future of technology, thinking about what investors are really interested in. Is definitely IP, and we've had a fantastic time working with Keltie, and it's really about learning how to do it, and I think the workshop is designed for that today. So you have a strategy, and yeah, we're in very capable hands. I think we'll just let a minute more to pass, and then over to Mark. As well, if you have any questions throughout, I will be moderating, so I will be asking questions as they come up. Or what do you prefer, Mark? Do you prefer to?
We should hopefully we should hopefully get through this in maybe 35-40 minutes, I guess, something like that. So I mean, we can take questions at the end, perhaps.
At the end.
We tend to we come in and out of the same topics a couple of times. So it may be that we introduce something and then come back in a bit more detail later on, which might answer some of the questions. But yeah, then at the end, happy to have an open Q&A. If there are any. And if there are any sort of areas that we haven't sort of expanded on enough in this presentation, then we can go into those as well. The only thing I would say is not to talk about anything that's confidential, as we'll mention later. Keeping things confidential is extremely important. So yeah, but any general questions, we're more than happy to cover.
Okay. Yeah, perfect. I agree with having Q&A at the end. So if you have any burning questions throughout, maybe just put it on the chat, and we'll come back and read them at the end, and we can have a Q&A after the presentation. So I think without further ado, you can start. Thank you very much.
Thank you very much. Well, hello everyone who's either watching live or maybe on a recording. So we, by which I mean myself, Mark Richardson, and my colleagues Samantha Walker-Smith and June, who's here with me in the London office, are going to take you through some aspects of intellectual property, touch on what is intellectual property, the different types, and then a bit more detail on patent-related issues and also issues to do with trade secrets. There can be a trade-off between those different areas. So we're going to take you through all those, and hopefully this will be a useful presentation. So just sort of set the scene for what we're going to talk about. So there's various different types of intellectual property assets. So we'll talk about patents, trademarks, designs, trade secrets. And it is possible to just always file for a patent, regardless of whether it's a good idea or not. So we're going to maybe slightly unusually for a patent attorney, we're going to encourage people to think about the reasons why you might not want to file in some circumstances for a patent application, whether it's the right thing commercially or not, and work out basically what is the best thing to protect, the best order to protect things, make your portfolio work for you, and mostly to align whatever your IP portfolio is with your business strategy. And the strategy is very important. It can be quite easy just to fall into the trap, as I said, of filing for everything that comes along, and that may or may not be the best way to use your resources, and it may not be the best way to make the most from your IP in terms of monetizing it. One thing that is important, well, a couple of things are important here. The last two bullets on this slide, it is important to have a strategy for your intellectual property, if possible, to work that out and have some guidelines as to what you're aiming to try and do. And as with all things, there is a cost element to filing for registered intellectual property protection. And so it's important to include the budget or the expected sort of scope of the budget for implementing whatever strategy is that you want. And most patent attorneys, trademark attorneys will be able to give you a reasonable look forward in terms of costs. Most of these procedures that we're going to be talking about are relatively predictable in a large degree. There are certain elements where maybe the timing is a bit uncertain, but in most areas it is possible to give some feel for what the cost of things are. Some considerations. I said sometimes you may or may not want to protect things via the patent system, or you may want to protect them as trade secrets. There are some things that you will consider for that, and these things will come back to later. So when we refer to novelty here, this is a patent concept, meaning is something new. So if, to take a trivial example, I attempted to patent a table with 4 legs. There's going to be plenty of examples of tables with 4 legs, so that's not new. It lacks novelty. It's not going to be patentable. If I wanted to patent a table with 563 legs, you might question my sanity, but you're probably not going to find a document that discloses a table with 563 legs. So you would satisfy this novelty criteria. There would be something new. Whether it's inventive or not is another matter, but working out whether what you're doing and want to protect is new is one thing that you should be doing, because it may or may not change the strategy you've got in the way that you either protect or disclose your IP. And we'll come into that in a bit more detail later on. One of the other things is whether it's commercially valuable. It's no good filing for a patent application if it doesn't actually support the business aims. If you do file for patent protection, are you going to be able to detect someone who's infringing you? That's another matter to consider. It may be that what you're looking to protect would go completely unnoticed if a competitor was doing it. And that may change whether you decide whether you want to file for a patent application or not. And finally on this list, are there any pressures, outside pressures, for you to disclose what you're going to be, what you potentially might want to protect? And if so, your patent attorney needs to know, because patents need to be filed before disclosure has happened. And so these are all considerations that you should have in your mind. They should all be linked into whatever your IP strategy is. And that final bullet point there is it can be easy to fall into the trap of wanting just to protect everything that comes out cool that you've developed. But if it doesn't align with the strategy and with the business aim, then maybe not. That's not the best thing to do. I'm going to hand over to June in a second, but what June is going to take you through is there are different types of intellectual property protection, and they break down broadly into 2 groups. One group, you actually have to do something to get it. So you have to file for a patent, you have to file for a trademark. But other things, you don't have to do anything really to get the intellectual property in question. So copyright comes into being automatically as you record something in writing, or if you've written some music, if you're writing down the musical notation, or if you're sculpting something or painting something, copyright becomes into existence as you create the item. And in particular for AI related innovation, is possibly a bigger consideration around trade secrets than there might be in some other areas. Probably there's going to be a combination of both techniques in terms of protection, but you may also find there are elements of copyright that are also involved in terms of protecting your IP assets. So with that, I will pass over to June, who is going to take you through the next step.
Yeah.
Oh, I think we can't hear you.
Yeah, sorry about that. So yeah, I'm June. I'm a trainee patent attorney at Keltie. I'm ChemBio team. So as Mark has just described, I think I'm going to explain on the points, the different IP rights that requires registration and other IP rights that does not require registration. So I think one of the main things you might associate like intellectual property or patent attorneys with is patents, which relates to technical inventions, as you can see on the right, but not just the products or apparatus. Patents can be related to method of manufacturing or method or the processes of performing several steps. Another IP right that requires registration is registered designs. And the picture you see next to that is a design of a trunky, which is like a portable bag with wheels on the bottom. So with registered designs, you can designate like shape and visual appearance of an article. Another one is registered trademarks. And what you see there is the UK's first trademark, which has branding or other features that are distinctive of origins. Another example can be domain names. On the other hand, there are IP rights that do not require registration, such as copyright or design right, and which is like automatic rights associated with artistic creations or literary works, including computer program code. Also, the picture you see on the bottom is common law trademarks. So, I mean, this is definitely different from registered trademarks that I've explained in the previous slide. And other examples of IP rights that do not require registration includes know-how or confidential information, which we will discuss later when we're talking a bit more about trade secrets. And there's also database rights. Yeah. So a little bit more about the patent. I mean, we have all heard about it. I think we know what it is. It is the right or the monopoly that enables the owner of the patent to stop or prevent someone else from making use of an invention. So it protects technical inventions. And as we will discuss later, there are a few criteria that is required for an idea to be patentable. So one of them would be novelty. So if you've ever developed something you think is new or solves a problem, which is another criteria, which is inventive step, then you may have a patentable invention. However, it's important to notice that to be enforced, a patent needs to be granted. So this is different from just submitting or filing a patent in the beginning. To enforce it against potential infringers, it needs to be granted, which is the last step of the patent prosecution. Another important thing is that, well, in academia and many inventors, I think we do get excited, and there is a lot of, pressure or excitement so that people can upload what they have been working on their website or could publish it before you file the patent application. And that could be really dangerous because even if it's your own disclosure, even if it's very obvious that you have worked on it as the inventor of this idea, that could prevent you from getting a patent through to grant, because what you have posted on the website or what you have published, the article that you have published previously, that could be identified as the prior art by the patent office. So yeah, another point of disclosure is like confidentiality agreement. So if you need to disclose an idea to an investor, but thinking about filing a patent application before you do that. Yeah. So to protect your idea is one of the biggest reasons to file for a patent, to use against competitors, to have a monopoly over the idea which is your original idea, and to control collaborators. Yeah, as you can see here in the example, you can stop your supplier from selling elsewhere because you have a patent on your idea. You can also, as we'll discuss later, you can monetize your IP or patent in this case by licensing these out, or just the fact that you have the patent can deter your competitors from, well, pursuing the similar idea. And it is also a good exit strategy later, or it could, I mean, in the UK, there's a tax-related scheme called Patent Box. So yeah, there are so many reasons to file a patent. Yeah. So, but then, of course, there are many factors that needs to be considered when filing a patent. The registration process until the grant, all the way to the grant from since you filed the patent, it might take up to 5 to 6 years. And quite obviously, it's a territorial right, so you have to file patent in every single different jurisdiction or countries that you would want to have this idea protected. Is the idea patentable? What kind of rights does it eventually provide? And another important question to consider is that once you've filed a patent, there is a requirement to disclose the content of your patent, which will be about 18 months from the point of your filing. So your idea is now disclosed. It can be read by anyone else in the world because the document is now public. So that should be considered. Application could be refused, or the scope of like the claims or the ideas you have initially filed, what is eventually granted could be a very limited form compared to what you have wanted to protect it in the beginning. So that might be another factor. And yeah.
And that's you. So we're now going to hand over to Sam, who hopefully will be able to take on the next section about software-related inventions.
Hi, I'm Sam. I hope everyone can hear me okay. I'm also a member of the software team at Keltie in the same group as Mark, and I'm also based in Cambridge, so I essentially head up the software group in Cambridge. So it's quite fitting that I'm now going to talk to you about whether your software and how to know whether your software invention qualifies for a patent or not. So I think, as Mark briefly indicated before, there's the usual 2 points for a patentable invention. So step 1, whether it's new, novel, over anything that's been published, including your own publications, but also whether it's then inventive and non-obvious over everything else that has been disclosed. And then specifically in relation to software inventions, there's also a third aspect that needs to be assessed, and that comes into play, which is whether the invention is itself technical, because this is a requirement for patentability in Europe and the UK. And when we say technical, there's various different ways of assessing whether a software invention is technical. Some of these relate to whether, for example, it can provide some kind of technical effect outside of a computer. So there'll be examples later. So that's one option, whether it does something concrete and real world outside the computer. Another one is actually in relation to the computer's operation itself. So whether the technical effect has something to do with how the computer architecture works, and or whether the computer itself is being made to operate in a new way. And then there's an additional point, which is the computer being turned into something better? So, for example, is it running more efficiently and more effectively as a result of the invention? And yeah, additionally, sorry, there was one final point on there, which was, is the invention actually solving a problem rather than just giving you a way to get around the problem? So, for example, and specifically in relation to AI, because it's quite a hot topic at the moment, so we've got a couple of examples for you about what would and wouldn't be considered technical and allowable on that front in Europe. So, for example, if the application was applied to a clearly sort of technical field. So, for example, the software was used to control X-ray apparatus or cryptography, or that's any of those options, that would count as some kind of technical effect and the invention being technical. Whereas by contrast, for example, typically when it's applied to a field that is not necessarily a standard technical field, so for example, in some kind of business or administrative related fields such as finance, commerce, advertising, or linguistics, so like natural language processing, for example, that might be less likely to result in an allowable technical effect, although that does not necessarily mean that just because it's applied to that field, it's not technical. You will need to look under the hood, as it says, and kind of work out if there's anything else actually going on under there. So more specifically in relation to AI patent applications, as June mentioned, there's a sort of level of disclosure that's required for a patent application. So that comes through as the patent bargain. So you're allowed to get a patent, but in return, you have to disclose how you do what you do. That's the only way that you can get to protect it. And there's quite a bit of debate in patent offices about exactly how much information you need to disclose to allow someone else to do it, and potentially in relation to AI and to enable you to achieve the effects of your AI, that can potentially be a higher bar. So you might need to include quite a lot of information about how your AI model was set up and trained. So, for example, input data, the model structure, and all sorts of other things that might be relevant, that would allow someone to be able to generate and train the model in the way that would allow it to achieve the effects that you are able to with your invention. And yeah, so that's sort of, I guess, the main point really about the level of disclosure, and it's sort of how comfortable are you with disclosing that level of detail in order to get a patent application, in which case you may or may not actually wish to go for patent protection, depending on how much you want to disclose on that front.
And
that concludes me.
And that potentially leads us into looking at trade secrets. So in comparison to the patent system, there's no formal registration requirement for a trade secret, but there are some conditions you still need to meet, one of which obviously is it a secret. You can't keep a trade secret with something that's in the public domain, but also it needs to have commercial value, and you need to have taken steps to keep it secret. So you need some kind of record, which possibly might go along with employee training, so that you can actually show that these items here we regard as sensitive to us, they're of commercial value, and we've taken steps to make sure that everyone that works for us knows that these cannot be disclosed and what the conditions are under which somebody can and can't discuss these outside of the company. Potentially, this might be regarded as a bit of a risky form of protection, because whilst you can maintain these secrets, at the moment that they become disclosed, and if that happens by accident or deliberately, if someone's done it, then the secret is out. And then whilst you might have some kind of contractual remedy, if somebody's done that, in terms of the sensitive information being out, then it's out there. So in terms of keeping a register, then these are some of the factors that you need to consider. So it can't just be, you know, one and done document. It needs to be something that you keep up to date. It should be set up in a way that should be clear to people how they should complete it and how they should follow it, and also what they should do to maintain the confidentiality of the information they're putting into it. So some sort of other factors maybe to think about with trade secrets is just because you're not protecting it via registration route like a patent system doesn't necessarily mean it's going to be the cheap option. If you're going to do this properly, then you're still going to be spending some effort in setting up the system. You're going to need to have some sort of consistent internal policies as to what should and shouldn't be regarded as trade secret, how you mark that up. Maybe you also need to consider about that not everything is going to be a trade secret. You know, there might be a tendency to try and think that anything that is to do with the company is a trade secret, but that might not be the case. How you set up a non-disclosure agreement, if you do need to disclose something, and how your employees should be briefed on how all this works. So then that sort of might lead into the question, so which route is best? With the patent system, if you can get a patent through, it will be relatively strong right. As June said, it's a monopoly right, so it stops anybody from using your idea, regardless of whether you know, they've developed something later in a completely independent way. Even if they didn't know what you were doing, then you've still got the right to stop them from doing it. There are some costs involved with a patent application, and they are not insignificant, and they do stretch out over time. So the whole patent process could take years. It can be sped up, but it can take a long time. So you have to factor in that there are going to be costs throughout its life. And as we've mentioned, there is a risk that you might not get a patent granted. So once your patent application publishes for the first time, which is a year and a half after you filed it, at that point, you may not know whether it's going to grant. And if you do end up with a refusal, then the publication has been made. So you've disclosed to the world what you're doing. So you do have to weigh that up. And obviously, as Sam was saying, there are, you know, the disclosure requirements may be such that you need to consider exactly what you're disclosing, particularly in an AI-related invention. And you may choose to patent some things within your company and not others. So I've got a client that is doing something in the field of robotics and AI. They've got items that will be sold or will be client facing, and those things they're looking to protect, but they've also got techniques that they're using that make their process easier to come to a finished result. And for that, they're deciding to keep that confidential. So they have a mixed process and a mixed procedure. So that's sort of like an overview of the different types of IP that we often come across. So we thought it might be also useful just to sort of run through how you might use patents and trade secrets and know-how and the various types of IP to raise money, possibly, or how they will protect your business interests. One thing in all of this to consider is the ownership of your intellectual property. IP is a property right, and just like a house, it can be bought, it can be rented, it can be licensed out. So it's important that you know who owns that right, and the provisions that govern the different types of IP rights are slightly different, and they can be things that kick in automatically. So, for example, an employee within a company who is employed, let's say, as a development engineer for writing software code, anything that they come up with almost certainly is going to be owned by the employer under UK law. But if you contract the same person who's not an employee to do the same job, then the rights don't automatically come over to the company unless you put that provision into your contractor agreement. So it's important to know who owns the IP and to make sure that you're taking steps to make sure the IP is in the correct place. It covers all types of IP, and you can find horror stories, for example, in like people that have released branding exercises with a logo which they thought they owned because they paid the artist for the logo, but the copyright was never assigned, and they find out 2 years down the line that they're on the wrong end of a dispute because they've not tied up the provisions at the outset. So it's important at the beginning to consider who's going to own this. And one other factor that I might just mention in there is that of joint ownership. As a rule, a patent attorney is probably going to be quite hesitant about recommending joint ownership of any IP, to the extent that I wouldn't, if at all possible. Depending on the rights that you're talking about and in which countries you're talking about, the joint owners can have different rights that they can exercise without the permission of the others, and particularly in cases where you've got a sort of size imbalance between the two or three joint owners, or even more, you may find that some owners can do a lot more with the IP than others. So it's much easier that it's owned by one person and others are maybe licensed to use it in certain ways. We talk a little bit about monetizing patents. One of the options is to license it. So you can license both a granted patent and also a pending application. You can license it to another company within your company group, perhaps, or if there was like a manufacturing arm, you could license them, or you can license a third party. You can monetize that in different ways. So the royalties you get from that, you may just license the right to work the invention that's explained in the patent, but you might also additionally license your know-how. So you may find that in certain fields, it's beneficial to, if you're the recipient of a license, to also ask if you can get the sort of technical expertise on tap from the inventor. And you may, as the licensor in that case, you may say, well, if you want that right, you need to pay more for it. Some other ways that patents can be monetized. You sometimes find you talk of patent pools, so especially in areas where there are standards. So in the telecoms area, it's possibly one of the main ones. Patents can be submitted there, and the patents that are part of the pool will get, where there is a license to use the standard patents, will get money back from that. The traditional thing that people think about with patents, I guess, is taking them to court. So you might get something out of an enforcement action, though the number of patents that end up in court is quite small. And usually something has gone significantly wrong for a long time between the parties involved, which meant they haven't come to some kind of equitable outcome beforehand. And you can also sell. It's one of the big things, you can sell your patent. So if your business strategy is that you're going to have an exit and you want to be bought out by somebody buying you may find that you're much more valuable if you've got your intellectual property strategy has been implemented from the outset, and you've made good choices in what you protect, and therefore that's a better asset for them to take on. There's some other less common strategies which we've just mentioned there. It's possible to get a loan out against a patent, and allegedly Thomas Edison, when he invented the light bulb, did secure a loan against the patent, which enabled him to start General Electric. But those are probably less common. Sort of coming back to the agreement side of things, the other thing is make sure everything's in writing. It's very easy at the start of a business relationship to start things on a nod and a handshake, but if people's recollection varies, or if people come and leave the group, if you've not written down and properly characterized what's going on, then you can get into disputes. And a contract doesn't need to be huge. It just needs to make sure that it's clear, that it reflects the wishes of everyone that's going into this agreement at the beginning. But it is even though you don't have to have the longest agreement in the world, it is always worthwhile making sure that you've had it sort of vetted by a professional, so that you're not making any obvious errors. So I mentioned a bit about licensing patents. You can also do the same for trade secrets, but this might be something that you would think about differently. And one of the things you might think about there is how easy it is to keep the secret, compared to something where maybe it's going to be difficult to keep something a secret. So the example we've given there is the Coca-Cola recipe, which has been knocking around for many years and is known by a handful of people. So it's quite easy for somebody to keep a lid on that, and it's commercially quite key to the company. But if there was something where, so in that instance, they're not going to license it because they want to keep it all in-house. But if something you might regard is, well, this might not be quite as easy to keep a secret, people might be working on it independently and come up with it. It might not last too long before somebody's come up with it. Then maybe you either want to license it, or you maybe still want to keep a lid on it and just use it for the edge that it gives you for as long as possible. So there might be slightly different ways, I'd say, of using a trade secret in this aspect. If you do license a trade secret, then it needs to be clear what's being transferred. Now, you might not want to put that in the agreement itself. You might need to reference something that's separate to the agreement but can be referenced by the parties. But you do need to be clear about what's being transferred or licensed, and also what obligations the recipient has on that information. So, for example, at the end of whatever the arrangement is, what happens? Do they destroy the information? Is it something they can hand back? Do they have any residual rights? And this sort of builds on that, really. You need to be clear about when things end, how things terminate. If there are any developments in that period that you've licensed out the know-how, who's going to own it? It may be that you want to retain ownership of that yourself because you were the originator of it. And all these things need to be factored in, along with how you're going to structure payment. And there are different ways of doing that. You can have a one-off payment. You could have, just to get access, you could have an initial payment followed by small royalties, or you could have varying levels of royalty that maybe reduce over time or change depending on how the information is used and put into practice. So I mentioned a bit earlier about the risks that maybe come from trade secrets, and there are some sort of put up here that you can certainly license it, but then you've got to wonder about whether giving the information to a licensee about how you're doing something is sufficient for somebody to then work around it. And there's always the risk that there might be a breach of the information, which might be accidental, but at the end of the day, it doesn't matter whether it's accidental or not if the information's got out. And there's a little bit there about sort of open sourcing stuff, which might drive associated services. This might also be, this is possibly more relevant for AI inventions. It may be that your biggest differentiator from your competitors is the data that you have, either you collect from clients that you've put together yourself, the training sets that you've used to train your models, and all these things can be monetized as well. If you spent time and effort putting it together, then somebody is more than likely going to want to, or going to be willing rather, to pay for that information. But then if you do try and monetize your data, then you're going to want to think about what happens if the information gets out, how you can detect it, and the level of access and where the access to what information you're giving out. And then it's moving into the sort of the final section of the talk. So some thoughts about how this all factors into your strategy. So your patent filings are really going to be there to support the business needs of your business. and the business requirements. So you're going to want to know that they're going to, in some way, either protect the ability for you to operate in the way you want to, or they're going to generate revenue in some way. And working out what you can or shouldn't file patents for can be a challenge. So we've tried to visually represent this. So at the beginning of the talk, we mentioned about the novelty concept is something new. I also talked about whether something is commercially valuable and whether you can detect whether a third party is using your intellectual property if they got hold of it. In an ideal world, you're going to be filing patents in the shaded section in the middle, because it's you know that you can get, or you strongly suspect you can get protection for it because it's new. You can tell that third parties using it. So if somebody does infringe, you'll be able to tell, and it's commercially valuable to the business. Outside of that, you may have different factors in play. So it may be that if you can see the overlap between detectable and commercially valuable that's not new. Now you might say, well, is there any need or is there any requirement now to file? We don't think we have a novel idea. Now you might still decide you want to do that. You might still want to file, because you'll still get a patent pending status for some years, which may be enough to deter people from trying to muscle in on your area. So even though it might not be new, you might still want to go ahead. But at the top, the overlap between the newness rather, and the detectability, if it's not commercially valuable, then you might query whether filing a patent application is really worth it. If you're sinking money into a process, the patent process, that's not going to show you any return, then should you be filing? And what we put in there is, in that case, it might be better as a way of sort of a defensive posture that you publish what you're doing. So we do have clients that on occasion go, well, we've got this new process that we're working on. We don't think it's particularly new, but just in case somebody tries to patent it and then enforce it against us, just in case our assessment of the newness of this is wrong, let's publish, because it's not strongly commercially valuable to us. We're going to put it out there, and that would stop somebody else from filing a patent application, because to get a patent, it has to be new. So if you put it out there ahead of somebody else, then you could stop them. And then the overlap in the bottom left there between commercially valuable and new, but without it being detectable, is possibly where your discussions about trade secrets and whether you want a patent or a trade secret might be the stronger discussion to have at that point. Because if you can't detect a third party, do you want to file a patent application because it is going to publish after 18 months? And then if somebody else picks it up, you might not be able to work out that they're actually infringing you. You'll sometimes hear talk about creating a patent thicket. And this is just the idea that you can enhance your position relative to your competitors if you have a series of overlapping rights. Those might be overlapping patents of slightly different scope that sort of try and take ownership of as large a patch of innovation as possible. Or it may be that you mix and match your intellectual property rights, so that maybe you have, if you had a device, let's say, that the functionality of that device might be protected by a patent, but the look of it might be protected by a design. So something like a smartphone would be a good example of that. There are hundreds of patents associated with the phones in your pocket, but there are also design registrations that stop competitors from getting too close. And then on the trade secret side, if you do have a policy of keeping trade secrets as well as or instead of patent filings, then be realistic in how much you're going to try and keep secret. The more you do, the more difficult it is to keep control of everything. And in all of this, you want to link back what you're doing back to your original business plan and try not to get dragged sort of off topic, as it were, in chasing every potential intellectual property filing that you can, because it needs to support the business, and it all should have a value that you can explain if needs to. And this is particularly evident in the patent system later in its life. You may have filed a patent application that initially you thought was going to be the next big thing, and you got protection in a huge range of countries. So you might have ended up with, if you're a life sciences filing, you may have ended up with 20 plus countries that you've got protection in. But then as you've gone through the life of the product, maybe having 20 or maintaining 20 patents in different countries doesn't align with the business plan. It may be that one territory you thought was going to be a big market isn't. So it's always possible to revisit what you're holding and what you're paying for, and to thin that out and prune it down if needs be, so that you're not paying for stuff that you don't need. And then finally, on the summary slide here, so link your assets back to the streams. Try and demonstrate the worth of what it is you're trying to protect. If possible, can you link the patents into high worth inventions? So is it going to be commercially valuable? Is it going to be patentable? Can it be detected? Those are questions that you should always have in your head. And if you're not constantly assessing the value of your IP portfolio, patents as in particular, but also other things as well, maybe you've got a huge trademark filing program that you then don't need. Always question whether you need everything. So you can, clients sometimes set up annual reviews or reviews every couple of years to make sure they're not paying over the odds for things that they don't need anymore. And I think that is the end of our presentation. If there are any questions, I'm not sure how we're going to handle the questions, but if there are any questions, then we can certainly try and answer some of those. I can see there's one question about a copy of the recording, which I guess will be for Francisco to answer.
So thank you very much, Mark, June, and Sam. I wanted to ask you if it's fine to share the recording with the community. I'll just make sure that that's okay with you.
Yes, that's certainly fine with us. Okay,
perfect. So yeah, okay, we will share this forward with the people that are in the call for certain. And I have, Mark.
Well, I was just going to say, just briefly, if anyone has any questions that sort of occur to them after today, or if you're watching this on a catch-up service, and you've got questions that you obviously can't answer us directly, then feel free to drop any of us an email. We're all on the Keltie website. We're all more than happy to answer questions. And if you want something slightly more formal, we could set up an initial consultation. We run sort of 30 to 60-minute consultation sessions without charge, so that you can sort of get a handle on what is and isn't appropriate in your circumstances, and just an overview of what might be good to think about. So yeah, if anyone's got any questions like that after the event, then feel free to reach out to any of the three of us.
Yeah, that's perfect. And yeah, so Keltie is part of the platform, and you have access to them via there. So everyone in the community can see you in the platform as Keltie. So just feel free to click there and reach out to them, as Mark's sharing. And I have many burning questions.
Okay.
I'm just curious if there's people also on the call who would like to share the questions via the chat or raise their hands and ask. I think it's super interesting what you guys are sharing and doing. So yeah, I'll let people raise their hands or share in the chat. In the meanwhile, I think, if you can share, I think there's questions around making this very fine balance between sharing what you're doing and keeping it as a revenue stream and making a patent. So I think that's potentially a more difficult question, but I want to start with a question around maybe just the process of how it works. If you can just outline, how the process starts, how complex it is to actually get it, how long does it take, what are examples? I think maybe an example around phones or examples around artificial intelligence companies that you've experienced that have done this with you. So yeah, I think there's some there to begin with.
Well, I guess the first thing really is that there is a point of commonality between trade secrets and patents, is that they both initially start with don't disclose it. So before you've made a decision as to which of those two routes you want to go down, it needs to be kept confidential. Ideally, that means that you don't disclose it outside of your company, if at all possible, because that reduces the risk further about any information getting out. If you do need to disclose something for some reason, then I would certainly say that you would need a non-disclosure agreement. And it's always better to talk about to not disclose how you do something, but maybe the capability that you have. But ideally, yeah, decide on
Can
your.
you share more about what capability means in this context?
So if you were to say, I don't know, let's say there is a problem with image recognition in autonomous driving vehicles that don't have LiDAR, and they mischaracterize or don't see objects using their standard camera vision systems. There's a known problem. And we've come up with a way where we can increase the accuracy of identifying objects in high glare scenarios, let's say. You don't say how you've done that. You just say that you've got a way you can address it. And I think it's not being caught out and being sort of lulled into disclosing exactly how you've gone about doing that. You might have some, very novel techniques about, maybe the camera arrangement or the types of camera, whether you're looking in the visual range or outside the visual range, and there could be a whole host of ways that you might address the problem without having to put a radar system on the car. But you don't really want to get into that. You just want to say, I've got a way of doing this, and it's shown in tests, an improvement of X% over the best in class at the moment. So I think that's the starting point, is to always make sure that you don't disclose stuff. Certainly once you have, you can't keep it a trade secret, and you can't file for a patent application. So you've lost that choice at the outset. If you've got a very developed business strategy, that might be the choice between patents and trade secrets might be something you can answer in-house. But if maybe you need more input, you might be going to a commercial lawyer or to a patent attorney and talking it over with them. The trade secret protection, as I said, will probably require some internal setup in terms of registers, and you might want to think about a consultancy service that would help you set that up. And on the patent side, once you've taken a decision as to, something is going to be put forward for a patent filing, there's normally a period of, unless there's a disclosure pressure coming up, if you're coming up to a massive commercial opportunity and you need to disclose something in 3 weeks' time, then your patent attorney's got 3 weeks to prepare and file a patent application. But if that's not the case, if there's no particular time pressure on a disclosure, then you may be looking at, say, 8 weeks from an initial discussion up to the point where you've maybe got a document that can be filed as a patent application. And in that period, your patent attorney is going to be asking for to discuss what the invention is, to get a feel for what the essential elements of your invention are, what problem they solve, and then also gathering the level of detail that they need to describe the invention in the patent document. Once the document's ready, it gets filed. The filing process itself is relatively straightforward. And probably that whole process of the drafting and filing is one of the bigger cost parts of the process. There can be a temptation to try and natural temptation, I should say, to depress and reduce those costs at the outset. and there's good reasons to not to want to spend more than you have to. But one of the unfortunate or fortunate, depending on which side of the fence you're on, setups within the patent system is that you can't add to a patent after it's been filed. So if you leave information out, you can't put it in later. So if at all possible, you want your initially drafted document to be as comprehensive as possible. So it may be that, you know, spending an extra couple of £1,000 on the patent draft, though painful, might save you tens of thousands of pounds later in the process later on, because you've got a much stronger document. So you draft and file. You normally just file in one country to begin with, your home territory or wherever it is you're based, and then you've got a year before you start thinking about protection abroad. And then there's different ways of getting protection abroad and where you want to file. But as I said, the process can take years if you're left to its own devices. But if you've got a need to speed things up, certain countries like the UK and Europe, it's relatively easy to speed the process up. And so if you really need to get something granted for some reason, then you can do that. I mean, it's a very high level introduction to the process, I guess. Hopefully it was sort of what you were angling for.
Yeah. No, I think it's good to understand what it entails to do it and how long, and these like timelines are, I think, very helpful for anyone in the call. Yeah, I don't see any. I have more burning questions, so I'm just, if I don't. Oh yeah, Omer, go for it.
Thank you so much, for all your insights. I wanted to ask a question related to what you just said, as your final point. So I'm a co-founder at a startup that operates mainly like the host country that we mainly operate in is Germany, but also the UK. So far, we're only registered in Germany, but we're trying to register here in the UK. But you just mentioned, you should only really apply in one country first for patent applications, and then wait for that to sort of get approved before you think of doing internationally. In a case where you're sort of equally working in two jurisdictions, how would you make that decision, do you think?
So
would you like recommend, EU versus UK? Is there like a difference between those landscapes, do you think, in terms of IP protections?
Well, so there's maybe a few points there. So I may have inadvertently misled you as to how quickly the process starts in the first filing. So the only reason to file initially in one country at the beginning is really for cost reasons. I mean, you can, if you wanted to, simultaneously file in the UK, Germany, the US, and wherever you want to, but it's obviously going to increase your costs because each patent office will charge official fees for filing. So the patent system only actually asks you initially to start in one place, and then it says you've got 12 months to extend that protection elsewhere. So it just smooths out the cost profile slightly. The wherever it is you've started the filing, so let's say you start in the UK, it's unlikely that you would have got to a decision point by the point at which you then file abroad. So it's still a pending right in the UK when you then extend it out further. It's just for cost reasons, you might start in one place, but that's all you need for the patent system to begin with, is just one, and then you build from there. In terms of how you handle different territories, so in Europe and in the patent sphere, the UK is still in Europe. The European patent system has 39 countries now. So it's the EU 27 plus others, and it includes the UK. So there is a European patent system. So if you apply for a European patent, it's a good way of sort of reserving your position in Europe. You file one application in one place, the European Patent Office, and you get that examined by the European patent examiners. And if it grants, then you convert it into protection into individual countries. So then you might go, we want UK, we want Germany, but we would also like France and Italy. So you can sort of validate it in multiple territories. So that's possibly one way of handling multiple jurisdictions. If you're talking about things like Europe and somewhere else, so say Europe and the US, there's no single patent that can get you both those territories. You'd end up with 2 applications in parallel, and then they just run along parallel tracks on, left to their own devices pretty much. There'll be a US examiner who will handle the US filing. There'll be a European examiner who handles the European case. And it may be that you get one and not the other. It may be that you get both through to grant, and it may be you get neither through to grant. Just depends on the invention in question. And you may find that one's far easier to get protection through, and one's a bit more difficult, because they're sort of run independently. Hopefully that was sort of what you were sort of asking there.
It definitely addressed it. Thank you so much. Appreciate it.
Cool. Is there any other burning questions that there's in the room? I certainly have some. So I don't know, Mark, how are you feeling? Do you want to do 1-2 more questions and then we close the session?
Yeah, if you've got a couple more questions, and feel free to ask away.
Yeah, cool. I don't see any hands raised, so I'm just going to ask you a question around potentially, especially talking about AI, how to think about it when it comes to open source, like a strategy around that. I think the community, we had a conversation with Alan Turing where basically the entire conversation was around open source, and it would be super interesting to get your insights and views about like strategies or how to go about that inside an AI company.
So even though you open source something, that might, I think sometimes people think if you've open sourced it, you can't patent it. That's not always the case. I think if you're using something within an open source licensing arrangement, and you're doing it and respecting the parameters of whatever that license is, then you're sort of effectively granted the right to use the invention by the owner. But that doesn't stop the owner from additionally protecting their IP through a patent, because if somebody doesn't respect the license agreement, or if there's somebody outside of it, let's say completely, that is infringing, you can still look to enforce your IP through patent filing. And you may also find that there are, you may utilize other people's open sourced intellectual property, and you may find that there are sort of elements that stitch it together, that's your own creation. So you may find that you have IP that you can protect in the interface between other systems. So I think it may slightly change the way you think about how you protect, or how you're working, I guess, because if you're using someone's IP in that arrangement, then you need to make sure you're clear on what you can and can't do with it. But if you're the owner, it may slightly change the way that you approach things, but it doesn't necessarily mean you wouldn't want to protect something through a patent filing.
Yeah, no, that makes a lot of sense. And I think so related to that, my last question is around, so there is a bit of complexity in the process, and it seems to me that it's like, be very mindful and strategic about the detail of filing the patent, and like the detail on the technology that you're trying to protect. And so like, if you can give a case where a patent was successful, and I was interesting about, you said there's hundreds of patents in phones, and an example that was successful, an example that a patent was denied, just to understand like the novelty around being successful with filing patents.
So yeah, patents can succeed or fail in getting through the system for a variety of reasons. It may be that what you file you think is new, and it may be that your knowledge of the technology area and what you've seen out there suggests that what you've got is brand new. But the assessment that your application has is against, in theory, anything that's publicly available, regardless of whether anyone's actually looked at it. So if it's available in a public library on the other side of the planet, and it was published 40 years ago and forgotten about, but the examiner finds it, then that could be enough to stop you from getting a patent. So the sort of traditional, is it new and is it inventive assessments, you can get a feel for what's likely to be allowable just by knowing the field. But you do have to sort of acknowledge that you are going to be sent documents that the examiner has looked at from anywhere around the world. And sometimes they will catch you out, sometimes they won't. It's almost always the case that whatever you start with when you start your patent journey changes by the time it gets to the grant point. So I said you can't add any material to a document, but you can certainly sort of reshape it. So if you start off with a claim that your invention is, a very broad claim to what your invention is, you may find that someone has done the very broad idea before, but you've got some improvement to a certain aspect of that is actually new. So it may be that you start off claiming very broadly, but once you've seen what the examiner's found, you narrow the scope down to some things that's more defined. And as long as that narrower scope is still business valuable, then there's still value in the patent application. So even though the patent process might throw up things that can stop you from getting a very broad claim, it doesn't necessarily mean that you run into a problem as soon as the examiner finds something. And there can also, and another reason why maybe you can't get a patent through is for a reason that we don't like seeing, which is that we've not described the invention in sufficient detail. So it was touched on in the slides as we went through the AI section that Sam covered. It's important that part of what you're doing is disclosing in sufficient detail so that somebody in theory can reproduce what you're doing. And certainly in the AI space, there's been sort of some not change of position, but clarification of the European Patent Office position as to what is needed in a document. And certainly in that case, more is more, almost. Making sure that you've properly explained how you've done something and not left anything up to chance in terms of what you're assuming as knowledge of the reader, might mean that a sort of machine learning model related invention goes into more detail than you might expect, and you have to be comfortable with that. But the fact that you can't add material during the life of the patent means you do need to get it right at the beginning. And if you get an objection on the basis that you've not sufficiently described something, that's quite a difficult thing to get round. It doesn't happen that often, fortunately, but when it does come up, it's quite a difficult thing to navigate. So that will factor in, I guess, to how comfortable people are in terms of what they will and won't file an application for, and why you might consider certain aspects of your business to be stuff you do want to protect via the patent system because you're happy that you've disclosed it, but some parts of it maybe not so much. So you might have like some secret source that says, well, to optimize this neural network, if you did the industry standard, you'd be doing it after 10 years and you'd still haven't got an optimized network, but we've worked out a way of doing it in 2 weeks. That might be something you want to keep as a trade secret, possibly, because you might not be able to detect it very easily. But the bit that you actually then apply that to, so maybe your optimization is to apply it into, like, as I was saying, like an autonomous vehicle or something. You might want to protect the actual product side of it and the application of the output. So we did different considerations for different types of invention, and how much information you need to protect those different things.
Yeah, and that's where your comment about like spending more time at the beginning can save you, or can make you gain hundreds of thousands in the.
Yeah, if you've got a pattern with lots of fallback positions, then you can if needed, you can gradually step back through those fallback positions until you're hopefully left with something that's commercially relevant, and the pattern examiner's happy that you're clear of the prior art, what people have done before. But if you haven't got much detail in your pattern and you go from the very broad to the exceptionally detailed with nothing in between, then you might find you go from something that initially you thought was a good idea, a very nice broad pattern, to something that's so narrow, it's not of use to you. And there was, I mean, that might factor into when you file as well. So a colleague was discussing this idea with me the other day, and they said, if you imagine someone has come up with an AI-related technique that can be used to detect certain types of cancer, and let's say specifically it's, I don't know, prostate cancer. And that's the only thing that at the moment they've worked out how to use the technique for. You could file an application, but if you get challenged on a broad application of that technique, you haven't got anything other than the very specific prostate detection example. And so you might be forced back to that narrow disclosure and narrow scope of protection. Whereas if you postpone maybe filing for a little bit, you might work out, well, actually, the same technique can be adapted to detect different types of cancer. And maybe we need to provide a little bit more information as to how to modify the technique, but it's got broader protection. And then when you've come to file the application, you've then got a better argument to say, well, we deserve the broader protection that we're claiming. Yeah, that can factor into when you file, and it can also factor into how much money you spend at the outset preparing the patent document.
Yeah, no, I think it's really something that seems also like an art of being able to understand with the lawyers and how to prepare all the documentation very precisely, and
yes,
also very strategic as well.
Yeah, and ideally your patent representative should be interested in what your business strategy is, and what your company aims are. You know, there might be a sort of, you go back 10 years, you know, patent attorneys might just say, well, we'll protect whatever you send us, you know, tell us the idea, we'll file the application for you. But really they should be questioning, well, does that support your business strategy? Is it something that's going to help you long term? If you're suggesting that you want to protect this in 10 countries, actually, is that needed? Because you only work in one and your main competitors only in one other. So do you only need 2 countries protected rather than 10? So yeah, there should be an ongoing dialogue, ideally, between you and your representation, because it can only make the outcomes for you better.
Yeah, it's super clear, and I really like the strategic perspective that you bring in. Yeah, thank you so much for your time, for this workshop. If there are no more burning questions, I think we can thank June, Samantha, and Mark very much for their time. Certainly I do, and we can let people drop the call. Thank you very much, everyone, for joining.
Thanks a lot. Thank you. Bye.
Yeah, thank you for the workshop, and
okay.
Speak to you
Bye,
all soon.
guys.
Bye.
Thank you so much. Have a great night.
Thank
Thanks.
you. Thank you, Omer. Thank you very much.